reference to the instructions. We aren't sure if the defendant can be found guilty if we find he indirectly, willfully threatened or attempted to cause physical injury to Alexander Bradley, in addition to satisfying the second and third elements. The explanation paragraph only says below the three elements, only says directly. So it's a reference to the elements listed for intimidation of a witness in the instructions that I gave, and then a reference on page 53 to the language of the statute. And I do note the indictment as it was returned alleges and tracks the statute that the defendant on February 13, 2013 did directly or indirectly, and then goes on to state conduct and the intent to impede, obstruct, delay, harm, punish, or otherwise interfere. So that is the question the jury has submitted. I've taken a very quick look at the case law while I was waiting for counsel, and I must say I don't see any cases, at least jumping out in the brief scan, relating to indirect interference. I think the best way to handle this, given the hour of the afternoon, is to bring the jurors down and instruct them that I will instruct them and answer the question tomorrow. Give you all an opportunity to consider what the appropriate response ought to be overnight, rather than try and rush a response. Commonwealth, what do you say to that approach?
That's fine, Your Honor.
Defense? I'm sorry? All right, why don't we have our jurors come down?
All right.
Madam Forelady, I've received a note with, I think, your signature submitted on behalf of the jury and dated today that references the second indictment in this case, that is the indictment for interference or intimidation of a witness, and references, in addition, the instructions that I gave you in written form, referring to page 53. We aren't sure if the defendant can be found guilty if we find he, quote, or underlined, indirectly, willfully threatened or attempted or caused physical injury to Alexander Bradley. Third elements, and then pointing out that the list of elements references only direct conduct rather than direct or indirect conduct. And it is a very insightful question by all of you, and it's a question that I think I will answer first thing in the morning. That is, given the late hour of the afternoon, I want to consider it a little bit more and discuss it with the attorneys, and then have an answer for you folks in the morning. Given that we're coming close to 4 o'clock, what I'd ask is that you resume deliberations unless this is the only issue remaining in your deliberations, in which case tell our court officers that you've gone as far as you think you ought to go for today, and will suspend until tomorrow morning. All right, with that said, our jurors may be excused.
All rise, please.
The expectation that I'll be answering this question about 9:15 tomorrow morning, so please try and be here on time with your respective responses. To the extent either side want to see the question and review it, it is available for your inspection. All right, we'll be in recess until we hear from our jurors.
All rise.
Now and tomorrow morning, you avoid any exposure to this case. Please don't discuss it. Don't read, hear, or see anything about the case outside of court, and don't attempt to learn anything about this case outside of court. To our poor suffering alternates, thank you so much for your patience. I would recommend War and Peace as an appropriate novel during the course of deliberations. But thank you for your patience with us as we continue this important process. And to our deliberating jurors, thank you all for the time you've spent. I don't think anyone who hasn't sat on a jury can understand the intensity of focus where you sit for 6 or 7 hours, focused solely on evidence that you've heard as a group, and the concentration necessary to do that. And I thank you all for performing that function, both on Friday and again today, and for your hard efforts. We will suspend now to continue tomorrow morning at 9, and again between now and then, put the case out of your mind. See you all in the morning. Jurors may be excused.
Minutes at this place tomorrow morning at 9 o'clock. This court is now adjourned. Jurors, please step out. Watch your step.